support of our business community. So thank you, SCU, for being the 2020 Lunch and Learn sponsor. Our lawyers today. Lisa Stiver. Lisa Stiver completed her high school education at Steinbach Regional Secondary School. She now works as a practicing lawyer at TDS with a focus on corporate commercial law, where she is also chair of the firm's business law practice group. Leilani Kagan is also a graduate from Steinbach Regional Secondary School. Her legal practice is focused on corporate transactions, which include mergers and acquisitions, with a primary focus on owner-manager taxation issues, corporate reorganizations, estate planning, trusts, and commodity tax issues. Allan Stewart is the managing partner of the TDS branch here in Steinbach. He has been in continuous private law practice since 1975. His practice has included litigating lengthy and complex criminal, contract, and tort cases. In recent years, the focus of his practice has been on corporate commercial and estate law. On behalf of the board of directors and the staff of the Steinbach Chamber of Commerce, welcome. We are honored to have you, and we look forward to hearing you facilitate this session today.
Well, thank you, Michelle. I will begin with my presentation first, followed, I believe, by Allan and then Leilani. As Michelle said, we'd encourage you to insert any questions into the chat box, or there's also a questions box. I will try to monitor both as we go through our presentation, and we've allotted some time at the end to go through as many questions as we're able to. So once again, thank you for joining us today. My portion of the presentation is going to speak to contract law issues, particularly related to COVID, and a question that I've dealt with a lot over the last 3 months, which is, how can I get out of my contract? Or what can I do about a contract I have with a supplier or with an owner, a landlord, or a tenant because of difficulties that I'm facing due to COVID-19? In the law, there is a concept, and it's reflected in most commercial agreements, that provides for parties to be excused from their contractual obligations in the event of serious unforeseen circumstances. This concept is called force majeure. So the clauses are called your force majeure clauses. These clauses generally discharge a contracting party when a supervening event, which is beyond the control of anyone else involved in the contract, any other parties, makes performance impossible. Now, force majeure clauses differ in the way they're drafted and the way they are interpreted, but what I'll try to go through today is generally whether what a force majeure clause should contain in order for you to use it to assist you during this time. So when can a business rely on the current circumstances of COVID-19 as a force majeure event? Well, and this sounds like a very lawyerly answer, it depends. And it depends specifically on the wording of the clause and the nature of the party's contractual obligations. Specifically, there are 3 key factors that determine whether a party can rely on its force majeure clause during the COVID-19 circumstances. The 3 key factors are whether COVID-19 falls within the defined terms of your contract, has it sufficiently impacted your obligations, and then thirdly, what steps have you taken to avoid the impacts? So first of all, does COVID-19 fall within the scope of your force majeure clause? The threshold for this first test is one that is easily met by COVID-19. In some other circumstances, it can be unclear as to whether or not the particular event qualifies as a force majeure event. But force majeure clauses typically use words such as illness, plague, disease, or pandemic. At this time, there can be no dispute that COVID-19 is a pandemic. However, if you were consulting us in January, it may not yet have been defined as such. So we meet that test pretty easily with this particular event. If you are dealing with an event that is not specifically defined, if your clause does not include illness or pandemic, most clauses contain an all-encompassing phrase, usually acts of God. And so this could fall within that. The key is that it must be unforeseen and it must be not out of the control of either party. So once you've passed that test, you look at whether COVID-19 has sufficiently impacted your obligations. This is key. It cannot just be happening. I don't believe there's any dispute right now as to whether or not there is a pandemic. However, how has it affected your obligations? It is quite a high threshold. It can't be that it just substantially affects. It has to actually prevent or render impossible the performance of your obligations. So an increase in pricing or costs or a delay in the schedule is not considered a direct impact. That's an indirect impact, and that alone would not qualify. An example of this is if you are a manufacturing plant and you have an operation in Alberta and you have one in Quebec. And Quebec, as we all know, has been very hard hit by this pandemic, and Quebec had a lockdown much earlier on manufacturing and other industries than other provinces ever got to. So you were unable to ship your products from your Quebec factory. If you were then able to ship them from your Alberta factory, this would not render your performance impossible. It might just change the schedule or increase your costs, but you would not be able to rely on force majeure. And the last factor that you would need to consider is, have you sufficiently tried to avoid the effects? In law, it's a concept called mitigation. Have you tried to lessen the effects of COVID-19? So although the force majeure event is unforeseen, once it occurs, you are supposed to look at what the effects could be and take what steps you can. For example, social distancing. The province advocated very early on for social distancing within workplaces. So if you did not socially distance your staff or people in your manufacturing plant, and then as a result, you had to shut down because there was an outbreak of the illness, you would not be considered having mitigated to the greatest extent. Under the law, parties may ask for evidence of your steps taken to mitigate. So if you are an owner or a buyer of goods or services and a supplier wishes to invoke their force majeure clause, you may, under the law, ask for evidence of what steps they took, compliance with provincial protocols, compliance with local laws, to ensure that they did everything they could to avoid the effects of COVID-19. So in summary, if you look at whether or not you'd like to, or you'd be able to rely on force majeure, and Hannah, you can move to the next slide. You would want to make sure you review the specific definition in your contract. As I said, for this particular incidence of COVID-19, this is not a high threshold to meet, but in general, the courts construe it very narrowly and they interpret it very strictly. In this case, it would fall under illness or pandemic. Then you would look at the effect of the event on your performance on the contract. Inconvenience is not enough. It must be impossibility of performance. And third, you look at what you've done to lessen the impact of the event once it occurs. So what happens if you've done that, now you wish to exercise your rights? There are a few other provisions in your contract that you should look at. I'll go through these very briefly. Specifically, most contracts contain notice provisions. If you wish to exercise your rights under force majeure, you should give notice in accordance with the provisions of your contract. Dispute resolution. Some force majeure clauses require that you invoke the dispute resolution provisions of your agreement before exercising your rights under this clause. You should look at liability clauses. The idea of force majeure is that it's to protect you from any liability or any claims, but it is not absolute. So you will want to review the liability clauses in your contract to ensure that you're not then subjecting yourself to additional liability. And lastly, termination. You would want to review the termination provisions in your agreement to make sure that you are not terminating the agreement by exercising your rights under force majeure. Force majeure is a suspension of obligations. It is not a termination of the contract. So once the force majeure event has passed, the parties are still parties to a valid contract and the obligations resume. So what happens if your contract does not have a force majeure provision? And there are a lot of contracts as well that do not have force majeure provisions. What do you do then? There is a concept under the law, under a common law called frustration, and it's codified in the statute in Manitoba called the Frustrated Contracts Act. This piece of legislation and this common law right permits you to terminate the contract if it's been frustrated because it cannot be performed due to what would be akin to a force majeure event. So if you have a force majeure clause in your contract, you must first rely on that. If you do not have a force majeure contract, you could look at frustration. And the key to the frustration is the same as force majeure. There must be a supervening event not contemplated at the time that you entered into the contract. And again, as I said, there is no force majeure contract in your clause in your contract. The occurrence of this event renders the performance of the contract fundamentally different and impossible. So the idea of frustration is that what the two parties set out to do can no longer be accomplished because of this supervening event. Under frustration, which is different than force majeure, this does terminate the contract and can terminate the relationship. So what I would suggest for either force majeure or frustration, you would like to get advice prior to exercising either remedy, because this can irreparably harm a relationship with another party. And even though with force majeure, it's only a temporary suspension, there may be other ways to work around the period of time where your obligations are not able to be performed in a way that still preserves the relationship between the parties. And frustration is an ultimate remedy. There is no going back once you have determined that the contract has been frustrated. So now I would like to turn the presentation over to, I believe Allan Stewart is going to be speaking next about protecting the rights of suppliers. Thank you.
Thank you, Lisa. I'm going to just mention that the Builders Liens Act, which is the principal piece of legislation which protects suppliers and contractors. It's a very powerful tool that can be implemented by both suppliers and contractors. And I've argued both sides of these types of cases in court myself, sometimes for the contractor and supplier, and sometimes for an owner who's not satisfied with the product that was delivered. I can tell you that a contractor and a supplier is so much more able to enforce a proper invoice if they've registered a builder's lien under the Act than if they just have to sue for collection on the invoice, even though these two remedies are available. It's the Builders Liens Act that gives you the tools to really collect the way you should be able to collect. I'm always surprised that a lot of the suppliers and contractors don't make use of these tools. And one of the reasons, and probably the main reason they don't, is the fact that you have to file a lien within 40 days of certain events. And that's one of the things that is affected by this coronavirus pandemic. The time limit of 40 days hasn't been extended. So whatever you're dealing with has got to be still done within the 40 days, even though, for example, an owner of a house that you've done significant construction work, maybe you've replaced the kitchen or you've done some renovations, says, I'm sorry, you can't come back in my house because the risk of contracting the virus. That means one of the criteria for the 40-day triggers is the last day of work on the job. So you can go by 40 days. We've gone through 3 months of this already, where 40 days is long gone since you've been able to actually go in the house of the party you're doing the work for. That means that you're going to have to take some proactive step in filing a lien to protect your rights, even though you may not be arguing with the owner, you can still register a lien. One of the other criteria is whether or not the job's been abandoned. But a lot of these, because of the virus, as Lisa said in her presentation, the contract isn't terminated. It just may be extended. So if you're going to be going back in after the restrictions are liberalized, you can still reinstitute all of your lien rights at that point when you go back and start the contract over again. The other one is more to do with, you know, major contracts where there's a payment certifier, and that's usually there's architects who are payment certifiers, and there's progress payments throughout the course of the contract, and the trigger starts with what's called a certificate of substantial performance. That's not going to apply in most cases. It's the normal deal with a builder's lien is between a homeowner, let's say, and a trade or a supplier, and the goods are shipped and they're dropped off at the residence. The supplier could be a plumber, could be a kitchen cabinet supplier, any one of those. They're in a position where if you're getting any difficulty in getting paid, you register a lien first and ask questions later. Now, here's one thing about the timing of this 40 days that everyone needs to keep in mind. You should be rendering invoices which say that it's due upon delivery of the invoice. A lot of invoices just have a standard wording says payable within 30 days. Well, just keep in mind that 30 days is if you've stopped work, you've finished work, you've completed the job, you're off the site, in invoice, that 30 days eats up a good portion of your 40-day window to file a builder's lien. So I recommend to clients that you should really have a payable on delivery of the invoice type invoice for that kind of work. The second thing is that when you're going to see your lawyer, the worst case scenario for the lawyer is someone walks in with like 24 hours before the 40-day limit is expiring. It takes time to find the proper legal description for the property. So, you know, some of these are new homes. They don't even have a designated lot number at the municipality. So you have to go down and actually search what is the actual legal description of this particular residence before you can register a lien against it. Again, you know, give your lawyer a bit of time to do the things that has to be done to get your lien registered. This whole coronavirus has thrown a bit of a monkey wrench into that. As I said, the time limit is still running. You're getting along with the owner, and 30 days has expired because your invoice says payable in 30 days. You don't go to see your lawyer for another 7 days. Guess what? You're virtually out of time already. It also takes time if you're going to be registering this in the land titles office, and that's the only way it'll become a valid lien. You're going to have all of the application filled out properly, and the builder's lien application does include a declaration by the trade or the supplier that this statement that they're making is accurate, and that's usually done in front of the lawyer. So you're going to have an appointment with your lawyer. Again, with the restrictions and social distancing that has come into place with the pandemic, it's hard to get in to see a lawyer. It's hard to get these documents signed where it needs to be signed. So, and again, if you've only got a few days to get it in, that's a real problem. So it's one of those situations where you probably should arrange for a special appointment with the lawyer to make sure that the builder's lien is properly completed and that the declaration is signed. And then hopefully the lawyer can walk it down or have a staff member walk it down to the land titles office to get it registered. Now, some of these are being sent in by mail, And that again adds a time to getting the lien registered. And if you've only got 24 hours, it's not going to work by mailing it in. So all I can say is timing of these liens is everything. If you don't make it on time, you don't have a lien. And if you don't have a lien, I can tell you your ability to enforce that invoice is going to be extremely limited. You're back to a regular lawsuit. And if you're in a lawsuit with a really disgruntled owner who is very unhappy with the work, even if it's a good work, some find imperfections in virtually anything. And if you've got one of those that you're dealing with, all I can say is you file a statement of claim, you serve it on the owner files a statement of defense, and then they come up with numerous deficiencies that they say are inherent in your work. They say, as a matter of fact, I'm going to have it all replaced. I'm going to countersue you for the value of whatever it costs me to replace it. I'm not only not paying you, I want money from you. So this is what you're facing. When you have a lien, you're in so much better position. You also, when you filed a builder's lien, you have an implication of a trust on all of those monies that were advanced from the bank, or from if you're under a general contractor and you're a subcontractor, and if the money has been forwarded by the owner to the general contractor and the general contractor hasn't paid you, all of those monies that go down that line of command are subject to a trust. And you have amazing remedies if there's any sort of use of those monies for any purpose other than paying out the contracts that you've delivered on in that job site. So once again, timing is everything. You've got 6 months, you've got 180 days to file a claim on a breach of trust under the Builders Liens Act as well. So all of these time limits that are coming into play because of the pandemic, they're not extended, so they're still running. You've got to get everything in before it expires or you lose your rights. I don't know how I'm doing for time here, but I've literally talked about the Builders Liens Act for all afternoon. One of the things that I thought might be relevant here is, this is a rural community in the Steinbach area at least, and you should be aware that when you're improving land, it doesn't include, a builder's lien does not include work to do tillage and basically work on the soil on the land. It does include cutting down bush in order to make the land improve for that, but it doesn't include the actual agricultural tillage of the land. So if you're in that situation, you're not going to be covered by the Act. The ultimate conclusion of a builder's lien claim is the judge has the ability to sell the land where the lien was registered. So again, you have a bit of a leverage over the person who contracted you to do the work and hasn't paid you. So again, if you're a trade or a supplier, you have a lot of excellent tools at your disposal under this legislation, and you should be taking proactive steps to use those tools, not wait until that 40 days is expired and then you're just saying, oh, I missed it, I lost my rights. And that's basically what I would suggest. If you're going to do anything, as I say, make sure your invoice is due virtually on delivery. Make sure that you get in to see your lawyer if you have any concerns that this customer isn't going to pay you, and make sure it's got enough time for that 40 days to expire. And if you do run into a disgruntled owner who says, you're not coming back in my house because of the coronavirus, but you know this person is going to be fighting you over your invoice, don't wait, file your lien, get it in, and then argue later. That's basically what I have to say. Thank you. Leilani, you want to take it from there?
Thank you. So I'm going to be talking about a variety of tax law changes that arose as a result of the pandemic. Hannah, if we could go to the next slide. Thank you. We'll be talking about payroll subsidies, the SERB, commercial rent assistance, the business loan account, and then just a review of some changes to CRA remittances and filing requirements. And then I'll touch on the collection and audit activities and how those have been amended since the arrival of COVID-19. Now, the two payroll wage subsidies I'll talk about are the 10% subsidy and the 75% subsidy. These were brought in April. It's not too late to apply if you have not started already using these. They are retroactive. So I encourage people who have not considered these wage subsidies to do so, in that there's a considerable amount of money that could come into your organization if you qualify for the programs. Now, the two main differences between the subsidies, other than the amount, one being 10% and the other being 75, which is significant, is that the 10% wage subsidy has no application process. You simply withhold the amount of money that you would otherwise remit as part of your payroll remittance. You calculate how much you're entitled to under the 10% subsidy, which I'll talk about in a minute, and then you withhold it from your remittance. Now you're allowed up to a maximum of $25,000 per employer. So for each company that has a payroll account, it's a maximum of $25,000. Does not matter how many employees you have. You're limited to a $25,000 subsidy. Now the difference with the 75% subsidy, as opposed to just the quantum of it, is that there is an application process. And that portal for applying opened on April 27th. It's still open if you have not yet used it. And it's not so much a subsidy as a rebate. Now the difference is in the 10% subsidy, the employer withholds the amount they would otherwise pay. And so you're not putting out money and asking for it back. In contrast, the 75% wage subsidy program is more of a rebate in that you have to pay the money first to your employees and then claim it back through the application portal. And so there is a cash flow timing issue with that second subsidy. It's a greater amount, but it does require you to pay your employees and then wait for the money to come back to you. Now that subsidy, the 75% subsidy, does not have a maximum per employer. Instead, it has a maximum of an amount per employee, and it's a maximum of $847 per week per employee. Doesn't matter how many employees you have, but it's an amount per employee. The wage subsidy this week was extended to August 29th, and so we're now looking at a much longer and more substantial rebate available to employers. So just going into that 75% wage subsidy in a little more detail, how does it work? Who's eligible? Well, an eligible employer includes individuals, trusts, taxable corporations, and tax-exempt corporations with some exceptions. So this includes charities, chambers of commerce, for example, nonprofit organizations, agricultural organizations, cooperatives. It also includes partnerships that consist of eligible employers, registered journalism organizations, and private schools and private colleges. So you are not eligible if you are a public institution, such as a hospital, university, a public college, or a public school. In addition, municipalities and crown corporations are ineligible and are not able to claim this subsidy. Now, if we turn to the next slide, this is a summary of the revenue test. So as I mentioned, with the 10% subsidy, there's no application process. But with the 75% was a subsidy, you have to apply and you have to show that you're eligible based on a loss of revenue. So this slide shows you the claim periods starting in March. There's 4-week claim periods. We're now into period 4 since it's been extended. And so we would just extend the same 4-week period starting on June 7th. But you'll see there's a claim period, and then there's a requirement for a reduction in revenue. In period 1, it was only 15% because the legislation was only brought in on March 15th, halfway through the month. But periods 2 and periods 3, there's a requirement for a 30% revenue reduction. And then there's a reference period for which you can then measure that reduction in revenue. Now, the magic to this is that if you become eligible in period 1, you're automatically eligible in period 2. And similarly, if you're eligible in period 2, you're automatically eligible in period 3. So if you qualified in March, you've got sort of a pass going through. But I urge people to look back over those periods and look at your revenue over a similar period the year before to see if you have this reduction. Now again, as it says in the chart there, if you're looking at, let's say, period 2, you can compare your April revenue from April 2020 to April 2019. Or you have the option of comparing it to the average of your revenue in January and February 2020. So there's 2 options for which you can qualify using your revenue comparison. Now again, we've extended to period 4, so you can take those dates and then just move them into the 4th period. If we just go back a slide now, Hannah. So once you've decided you're an eligible employer, and you meet the revenue test for at least 1 claim period and perhaps all the claim periods, you have to look at who are your eligible employees to apply for this 75% wage subsidy. And an eligible employee must be an individual employed in Canada. So it can only be your Canadian payroll employees that count toward the 75% subsidy. Now, an employee is ineligible if during a particular claim period, they were not paid by you for 14 days. So the claim periods are 4 weeks, but if in that 4-week period, there was a 14-day period where an employee was not paid by you, their remuneration for the entire claim period cannot be used for your 75% wage subsidy. Now, because CRA introduced this once we were well into the pandemic and some companies had already laid off employees or furloughed employees, they said if you want to retroactively rehire those employees so that they will then qualify and you can then add their payroll into your calculation, you can do so. But that means you actually have to go rehire those employees, then include them in your calculation for the 75% rebate. The one thing to worry about with this, though, and I'll talk about this in a minute, if those employees collected SERB, that was the Canadian Emergency Response Benefit of $2,000 a month, if they collected SERB for that 14-day period that they were off, they're going to have to repay that. So the government will not allow them to collect the SERB and then you include them as a rehire with payroll for the 75% wage subsidy. So you'll have to pay them, but they have to repay their SERB. In terms of the process for this wage subsidy, as I mentioned, there was an application portal that opened on April 27th. You can access it through your My Business account online with CRA. And you would then apply for the rebate. You would include in there all of your payroll for your employees. That would be salaries, wages, commissions, fees. Any type of amount that you would issue a T4 or a T4A in respect of goes into that calculation. I've had some clients ask, and CRA has now updated their website, you cannot include severance pay in that calculation. So if you did terminate an employee within a claim period and you made a severance payment, you cannot include that amount in your 75% wage subsidy. So if we go to the next slide, and one more to the 10%. This one, as I mentioned, is a much simpler process. There is no there is no application process. And for this to be eligible, you have to be either an individual, but you cannot be a trust. So for the 75% wage subsidy, you can be a trust. For this one, you cannot. You can be a partnership, you can also be a charity or a nonprofit organization, or you can be a Canadian-controlled private corporation that has small business income. So the 10% wage subsidy is a little more narrow in that respect, in that you have to have small business income. In the 75% wage subsidy program, you just have to be a taxable Canadian corporation. In terms of eligible employees, it's the same. It has to be an individual employed in Canada. And as I mentioned, the process is simpler. You just withhold the money from your remittances. You don't have to pay it and then wait for it to come back to you. And then how do the two programs interact? Well, they don't allow you to double dip. So the maximum you can receive is 75%. So if you've been withholding under the 10% program and now you've applied for the 75% wage subsidy, they will claw back on the 75% wage subsidy to the extent you received and withheld money under the 10% wage subsidy. So the maximum you'll be allowed to receive is the 75%. Now you don't have to worry about claiming this back if you've already been withholding the 10%. The application portal with the 75% wage subsidy has some boxes where you can check off what you've already received, and then the calculation will then grind down the amount that they would send to you. So that was it on the wage subsidies. The next topic I just wanted to touch on was the SERB. Now this was a very widely utilized program. It has not been substantially updated other than for the 8-week extension, which was granted in the last several days. So I won't spend too much time on it. This was technically just a temporary replacement for the EI program. I'm not sure how much longer they're going to run it. They may extend it again. So it's starting to look a lot longer than temporary. But the EI system was overrun with the millions of applications they were receiving when COVID hit. As a result, they moved EI into the CRA systems, and through, again, an online portal system, you can apply for SERB. It's $2,000 a month. To qualify, you have to have earned at least $5,000 of income last year from employment, including self-employment. And then the government introduced some additional criteria that allowed individuals to earn up to $1,000 over a 4-week claim period and still remain eligible for the SERB. Without that exception, you cannot otherwise earn any income in the claim period to be eligible for the SERB. It's a very quick turnaround application process online with CRA. It's an average about 2 to 3 days between when you apply and when you see the money in your account. It might take a bit longer if you are waiting for a check. As I mentioned, if you have employees who've received SERB and then you rehire them and pay them and bring them back onto your payroll for the 75% wage subsidy program, they will have to repay that SERB. Next slide. One other benefit that was introduced was the Canadian Emergency Commercial Rent Assistance Program, and this program requires commercial landlords and tenants to enter into a prescribed form of rent reduction agreement. And in this agreement, the rent is reduced to the tenant by 75%. So the tenant will pay 25% of their gross rent. The landlord then pays 25%, and the government pays the remaining 50%. In terms of qualification, there's really two sides to the whole qualification process. The commercial property owner has to qualify, and the tenant has to qualify. In this case, the commercial property owner has to have a tenant that is a small business corporation, and the corporation that owns, or the entity that owns the land, cannot be a government, with certain exceptions. The property owner can be a post-secondary institution or a hospital or a crown corporation. It just cannot be a government itself, federal, municipal, or provincial. Now, in terms of the tenant cannot pay more than $50,000 in monthly gross rent per location, nor can the tenant have more than $20 million in gross annual revenues, and that's calculated on a consolidated basis. And furthermore, and this is the issue, the tenant must have experienced at least a 70% decline in pre-COVID revenues. So the tenant has to meet the test of having experienced at least a 70% decline in pre-COVID revenues. And if those criteria are met, then both parties have to participate in the application period, or application process. Now, the eligible rent period is April to June of this year. There's a multi-step application process that requires, as I said, information from both the commercial landlord and the tenant. And in addition to the rent reduction agreement, the application process requires the parties to enter into a forgivable loan agreement, whereby the commercial property owner has to agree to certain terms and conditions. And this loan, if they fulfill the conditions, will be forgiven at the end of this year. Now, this program will be taking applications until August 31st, 2020. The next emergency measure, monetary measure that was put in place was the CEBA, the Canadian Emergency Bank Account. This is a very simple qualification process. It's any corporation with a bank account and a business number. These entities can then access a repayable loan of $40,000 that's repayable at the end of the year 2022. So December 31, 2022, this $40,000 loan is repayable. Failure to repay this loan means that interest starts to accrue on January 1st, 2023 at the rate of 5%. However, if you repay the loan in full by the end of 2022, then $10,000 is forgiven. So it's a $40,000 loan, $10,000 of which is forgiven if you repay by December 31, 2022. This is also a very easy application process, which is done through your financial institution. And then the last emergency measure I was going to mention, and this is relatively new, this is the Emergency Processing Fund. This program funds two types of activities. One is COVID response activities, which would be examples of adjustments made to existing production facilities to implement public health protocols. The funding for this type of activity is non-repayable, so it's like a government grant. The second type of activity that this program funds is strategic investments, such as improvements or modernizations of facilities. Now that funding is repayable, and all of these activities must be completed by September 30th. Now it's called a processing fund because it's eligible for entities that are in agricultural food processing, agricultural food manufacturing, and agricultural producers. And so in terms of food processing, it includes agricultural producers who are growing or raising product, which have a processing line which processes the products grown or reared at the facility. This also includes greenhouses that clean, sort, and package their production. The other eligible entity is an agricultural food manufacturing facility or agricultural producers who are converting or adapting existing greenhouses to increase year-round horticulture production. Note that seafood processing and manufacturing is not an eligible activity for the program. Not a huge deal in Manitoba, I'm sure. However, this includes cooperatives as well. Now, these applications will be accepted between June 12th, so just last week, and July 31st, 2020. So you have about 6 weeks to get this application in. And if you're successful, up to 25%, which is increased to 50% for small and medium enterprises, will be returned in terms of your eligible COVID-19 response and strategic investment expenses. So if you're a small or medium enterprise, 50% of your eligible COVID-19 response expenses and 50% of your strategic investment expenses will be covered. So that's it for the emergency funds. And I just wanted to then end on some updates on where CRA is with their tax payment and filings. So we've already passed some of these dates, so I'm hoping that everyone took advantage of these extended deadlines. The payment date for all taxpayers has been changed. Any income tax amounts that would have become owing on or after March 18th when this was brought in and before September 1 are now deferred to August 31st, 2020. Tax returns for individuals, the due date was June 1st, so I'm hoping everyone here who had a tax filing due date as an individual made their filing. And the tax return filing due date for corporations was set at June 1st for corporations that would otherwise have a filing due date after March 18th and before June 1st. So they got that extension of a couple months. And then the tax return filing due date for partnerships was set at May 1st. And then the last item I wanted to touch on was just on payroll. Oh, sorry, you know what? There was no question. I was going to say there are no extensions for payroll remittances and filings. Those all remain the same. Thanks, Leilani. So we do have a question that is something that you would be able to answer. I believe you touched on this in your presentation, but we have a question. If you are currently collecting SERB, is it possible to then still earn any additional income? If you're collecting SERB, you're allowed to earn up to $1,000 in a 4-week claim period and still receive SERB. And a second question that I believe you answered just at the end of your slides is whether or not there's any extension for PST remittances. On the PST remittance, and you know what, I did have a slide for that, but I think I took it off in the interest of time. No, the PST remittances now are, as of now, are current. As in you would be filing them as you would regularly. Correct. Okay. And I'm just going to check to see if we have any other questions. No, I believe that's all. So Michelle, we'll turn it back over to you then to wrap up.
Well, thank you, everyone. And on behalf of the Board of Directors and staff at the Steinbach Chamber, thank you, Lisa, Leilani, and Allan, for this very insightful and informative session. It's been an honor to partner with you today, and we greatly appreciate you taking some time to share your knowledge with our business community. So once again, on behalf of the staff and Board of Directors, thank you so very much for sharing with us today. Also, thank you to SCU for sponsoring this event and your ongoing support of the Steinbach Chamber, and for the attendees, for the Steinbach Chamber members for attending the Lunch and Learn today. Just very briefly, a few of our upcoming events. June 25, so next week, Thursday, from noon till 1, we have a virtual mixer facilitated by Summit Organizational Development. The last day to register is the 20th of June. Burger Days is coming back to Steinbach for the 3rd year, so look forward to that for September 12 to 19. We just sent the registrations out to the restaurants yesterday, so we already have a few restaurants participating, so look to an exciting community event coordinated by the Steinbach Chamber, September 12 to 19. And then lastly, our Business Excellence Awards and AGM is set for September 22nd. Voting for the Customer Service Award open today, so please visit our website at steinbachchamber.com to vote for your favorite business. Wanting to wish everybody a wonderful week, and we look forward to seeing you soon.
Thank you.
Take care.